Hello, my name is Burton Hochberg. I'm here to talk about the top 10 myths in Illinois divorce cases. I've been practicing law in Illinois for 37 years. I'm a partner with Schiller DuCanto Fleck and have been here for 25 years. We specialize in family law cases, and these are the questions that many clients ask where there's a misconception. Myth number one, is there an advantage to being the first to file? The answer is no. The first person to file is called the petitioner. The second person against whom the case is filed is called the respondent. There is no advantage to being the petitioner, nor is there an advantage to being the respondent. In Illinois, both parties have equal rights and responsibilities. The judge does not view the petitioner as the good guy or the respondent as a bad guy. Myth number two, probably the most commonly asked question, is Illinois a 50-50 property division state? The answer is it can be, but not necessarily. 50-50 division states are known as community property states. Illinois is not a community property state, such as California. Illinois is what is called an equitable distribution state. What that means is that the court will allocate assets and liabilities equitably, not necessarily 50-50, although in many cases it turns out to be 50-50. What's important to keep in mind is not just the percentage division, but the dollar value that is allocated to the asset or the liability. A 50-50 division with overvalued assets really isn't a 50-50 division, and certainly attention should be given to the dollar values of the assets and liabilities. Myth number three, frequently asked, is marital misconduct or bad behavior something that will help me in my case? My husband has had a girlfriend, or my wife spends money without any budget or regard to our finances. Are those factors things that a court would consider in the division of property? Generally not. Our statute very specifically says marital misconduct is not to be considered in either the division of property, the setting of support, the setting of child support, or indeed in custody determinations. The exception to that general rule is dissipation. Dissipation is defined as the expenditure of funds after a time that the marriage has gone through an irretrievable breakdown not related to the marriage. A simple example, gambling. If one spouse gambles, the court can consider that a dissipation and add the amount dissipated to that party's balance sheet as though it still existed. Myth number four, if I don't pay attorney's fees to or on behalf of my spouse, will that freeze him or her out and give me a leg up? Is it a good strategy? In Illinois, the answer is no. We have a statute that allows for temporary fees to be awarded from the spouse who is financially advantaged in favor of the spouse who doesn't have the financial resources. It is called leveling of the playing field, and a court does not hesitate to award temporary attorney's fees once, twice, or a half a dozen times during the pendency of the case. Most judges will not allow the inability of one spouse to access money to pay for his or her attorney's fees to be outcome determinative. The amount of fees that are advanced are considered a credit toward that spouse's share of marital property. Myth number five, joint legal custody means that the children spend half of their time with mom and half of their time with dad. That is not true. Joint legal custody is a legal term, and it means that major decisions concerning education, medical care, and religious upbringing are made jointly. It has nothing to do with where the children live. Where the children live is referred to as the visitation arrangement, the parenting schedule, and under a joint legal custody arrangement, the children could live with each party equally, but more often than not live with a primary residential parent and then a visiting parent, typically alternating weekends, shared holidays, and some weekday visits. Myth number six, if I have shared or joint legal custody and shared visitation schedule, I won't have to pay any child support. Not true. Courts are loath to not award child support. They will look at the parenting schedule, but they will also pay very close attention to the financial resources of the parties, and more often than not will award the less financially well-to-do parent with child support, provided that parent at least has 50% of the parenting time or more. Myth number 7. If I have no income, I can't be ordered to pay child support or maintenance. Not true. Illinois courts, as most states' courts, will go out of their way to protect children as it relates to child support payments. If a party does not have employment, the court can take assets from that person, set them aside in what is known as a 503G trust, and utilize the proceeds from that trust for child support. Courts will routinely require an unemployed spouse to keep a job diary. So the fact that somebody may be between jobs doesn't mean that they don't have an obligation to look for and obtain employment. In some cases, parties are underemployed. Somebody who can make $300,000 or $400,000 a year will be required to pay child support at that level and will not be allowed to pay child support at, say, $50,000 or $75,000 unless the lower paying job is a good faith employment. So courts will impute income to somebody who is not working and earning at traditional and reasonable levels. Myth number 8. This is straightforward. Most people think that all support payments are tax deductible. It is not correct. Maintenance payments, if there is language in the agreement that requires that the payments abate upon the death of the payee, are generally tax deductible to the payor and tax includable to the payee. Child support payments are not deductible by the payor and are not tax includable by the payee. Myth number 9. Clients often ask, if I don't like the outcome of my divorce trial, I can always modify it. Isn't that true? They ask. The answer is generally not. Once a judgment is entered as a result of a contested trial, it is not modifiable unless there is a substantial change in circumstances as it relates to either child support or maintenance. If there is a substantial change in circumstances relating to support, a court, after an evidentiary hearing, may modify child support or maintenance. Property terms, on the other hand, really are in stone in the absence of fraud, duress, or unconscionability. So once you have your trial, you're pretty much stuck with it unless somebody loses a job, gets sick, or there's a large increase in the expenses of the receiving support spouse. Myth number 10, permanent maintenance is forever. Not true. Permanent maintenance is also known as indefinite maintenance and is modifiable based upon a substantial change in circumstances. Permanent maintenance abates under Illinois law upon the remarriage, cohabitation, or death of the recipient. It is modifiable based upon a change in circumstances that is involuntary. A person who loses his or her job for circumstances beyond their control can petition the court and will get relief. If a person gets ill and can't work, he or she can petition the court and get relief. The more difficult case is where somebody wishes to retire. The courts will look at the economics of the industry and determine whether it's a good faith retirement or not. Thank you for your time. I hope you found this useful and interesting.